first speaker today, who introduced herself, is Cliona Robb. She's a director at ThompsonMcMullan Law Firm. She is the chair, was the chair of her former employer, Christian Barton's Sustainability, Energy, and Green Development Practice Group, and a member of the Energy and Telecommunications Department. She represents municipal, industrial, and commercial customers of electric, natural gas, and water utilities regarding rate service and transmission line siting. And she had mentioned earlier that she's the representation or the attorney for or counsel for the Virginia Energy Purchasing Governmental Association, which she'll go into more detail. She also works on renewable energy transactions involving solar and wind, and has been appointed by the governor to the Solar Energy Development Authority, which she serves as the chair. She also serves on the board of directors for the Virginia Renewable Energy Alliance, and I think you're the chair of that right now. Is that correct, Cliona? All right, so with that, we can hand it over to Cliona.
Very good. Thanks very much for inviting me. And as Joe said, probably most pertinent to this meeting is the hat I wear as counsel to VEPCA, the Virginia Energy Purchasing Governmental Association. And I share that role with Louis Monticello at my former firm, Christian Barton. So, the topic Joe asked me to address was the contract purchase of electricity by local governments in Virginia. I want to start out by saying that Virginia is unique in this regard because it's got what are called jurisdictional and non-jurisdictional customers. And by those, I mean customers that are subject to the jurisdiction of the Virginia State Corporation Commission and those that are not subject to the jurisdiction of the Virginia State Corporation Commission. All states have public utility commissions that govern electricity rates, terms, and conditions. Our PUC, Public Utilities Commission, is the State Corporation Commission, and it has jurisdiction over almost all ratepayers in Virginia. But there's a unique carve-out in Virginia law which makes certain categories of customers non-jurisdictional to the commission. And those categories are local governments, state governments, and federal government. So those accounts, like a City of Richmond account is not governed if it's served by Dominion. It's not subject to jurisdiction by the commission, and that is a kind of obscure statute because I tell people this and they say, well, where's that in Virginia law? It's well hidden. It's in Virginia Code Section 56-234, subsection B, and it says, it talks about how it's the duty of all public utilities to have just and reasonable rates subject to jurisdiction of the commission, but it says this condition does not apply to contracts for service rendered by any other public utility to any municipal corporation or to the state or federal government. So what this creates is an opportunity for local governments. If they so choose, they can, knock on Dominion's door, APCO's door, their electric co-op's door and say, hey, instead of just getting the rates that the State Corporation Commission sets for most customers, we want to basically control our own destiny and negotiate with you directly for rates. And VACO has played a big role in this throughout the past several decades. Right now, you've got the VML VACO APCO steering committee. So you help run the group that negotiates directly with Appalachian Power Company for the rates paid by local government accounts. And by local government accounts, I mean the accounts that are that govern usage by local governments. It doesn't mean that it covers all residents and businesses in your jurisdictions. It covers the use of your public buildings, essentially. So VACO plays a role in that. My group, the VEPCA, the Virginia Energy Purchasing Governmental Association, originally was known as the VML VACO, Virginia Power Steering Committee. And then back in 2000, when Virginia decided it had done decades of traditional regulation and it was going to follow the flow that the rest of the country was going in and look at deregulating electricity rates and purchasing competitively on the open market. When that happened in 2000, the VML-VACO Virginia Power Steering Committee said, you know what, if we're going to be making competitive purchases, we better get ourselves organized to more expeditiously go to the market. So they actually set up an organization under the Joint Powers Association Act. So the other statute that's of interest for this discussion is 15.2-1300, which is a joint exercise of powers by political subdivisions. So we went from kind of an informal steering arrangement committee approach to a more formalized approach, where if you want to be part of the VEPCA contract that's negotiated with Dominion, you have to officially join VEPCA. So you become a member of the Joint Powers Association. We've got bylaws and a board of directors, and so it's just we're doing the same function that we always did under VACO and VML. We're just doing a little more formally, and the VEPCA board meets quarterly. We have an annual meeting, which until this year was in person, but it's basically, in addition to contracting with Dominion, it's a means for those interested in local government energy issues to get together on a quarterly basis and kind of share learnings. So one of the things the VEPCA contract, which is up on its website, is about this thick. I've got a binder it has the master agreement, terms and conditions, the rate schedules and riders, has a list of VEPCA members. It has a refund attachment that we put in for a possible refund once the contract is over, and then it's got VEPCA riders. So the way it works is about every 3 years. We've had contracts as long as 7 years. Short as 3 years. We generally typically go about 3 years, 3.5 years, where the negotiation team. So the negotiation team currently consists of Susan Hafley from Fairfax County, Rick Gregg from Hampton Roads Sanitation District, and then council, and then our consultant, Glenn Watkins. So we sit down with Dominion every 3 years or so and say, well, here are the concerns of VEPCA members under the current contract. Let's address those concerns, which show up generally in the master agreement or the terms and conditions. And then we also do negotiations based on cost of service. So traditionally, when the way the commission used to set rates was it would take a look at the utilities cost of service, and it would say, okay, this is what it costs you to do business. This is what's a reasonable profit. And so we'll set rates based on the actual cost and a reasonable rate of return. Commission has gone away from that in recent years, not because it was the commission's idea, but because the General Assembly thought they would kind of give the commission some guidance on how things should be done. So for jurisdictional customers, those subject to the commission's jurisdiction, it's not. And Meade may get into it, may clarify this in his discussion, but to my mind, it's no longer just a traditional cost of service setting of rates traditionally, because what happened was when we started down the road to competition in 2000, we got to 2007, and the General Assembly looked around and said, there's a lot of people, a lot of other states that have gone fully deregulated. They told their utilities to get rid of all their generation, and market prices started spiking. And so the utility customers from those in Maryland, Pennsylvania, New Jersey, they were hurting. So our General Assembly said, you know what, deregulation is not such a great idea. So in 2000, we re-regulated. But when we re-regulated, we didn't go back to traditional cost of service rate regulation. We went back to I think it's unique in the nation, regulation, where the General Assembly provides lots of direction for the commission. So one of the directions, and you guys will have noticed this on your bills if you get bills from, say, Dominion or Appalachian Power, is we have base rates and riders. So one of the differences when we went back to re-regulation in 2007 was you got an alphabet soup of riders on your bills. So instead of the commission, every now and again having a big rate case for its utilities, and rates would remain steady until that next big rate case, what you've got now is a bunch of rider proceedings. So when a utility adds a new plant, a new generation plant, in many cases, that can go into the commission and get a rider to just add that plant onto your bill. So instead of the commission kind of doing an overview, saying whether you're earning too much or too little overall, they just automatically add a bunch of riders on your bill. And the General Assembly, and I know Meade will get into this, has guidance on how those riders get applied. Now for BEPCA, those riders actually also apply, because one of the things we do not. One of the things I'm most proud about in being a Virginian is the fact that we have a really competent staff in our State Corporation Commission. And I know this partly because I've had clients that work in regulated industries that have tried to hire away SEC staffers, and the SEC staffers said, you know what, don't think so. We're making pretty good money. We like what we're doing. So we have one of the more, I would say, professional staffs of public utility commissions. They know what they're doing, and I think they do a very good job of balancing the interests. I feel like when I'm in front of the commission in a docket, that I'm kind of on a level playing field. So even though I mostly represent customers and not the utilities, the utilities have 6, 7 lawyers in the room, and I'm up there representing a customer interest or a competitive supplier interest. But I do feel that everyone gets a pretty fair shot in making their arguments and producing evidence before the commission. So that's basically how but the one thing, and Joe reminded me to stress this, because we have a consultant of one, and the commission staff has a whole array of people. We normally time the VEPCA contract negotiations so they come after a big commission decision. So we want to take advantage of the fact that the for instance, with riders, when in 2007, when Dominion went to riders for its jurisdictional customers, they also insisted that VEPCA go to riders for its contract. So even though we're not under the jurisdiction of the commission, Dominion was persuasive. And so we still have riders on VEPCA bills. And that means that every January 25th, Dominion puts in a rider proposal for riders that are going into effect July 1st. So one distinction between VEPCA bills and jurisdictional customer bills is we have riders change once a year. So with other riders, they come in at various times and they can get changed at various times. We've tried to create some more budget certainty for members. So we asked Dominion on January 25th to give us its proposal for the riders that are going into effect July 1st. And then that lets us take a look at it, make sure we don't see any anomalies, and then they go into effect on July 1st. So that creates a little more rate certainty in terms of when the rates are going to change on VEPCA bills. So in that sense, although we can contract independently, we're also very much dependent upon what happens with utilities and the General Assembly, because a lot of times, although we're not automatically necessarily bound by how the commission sets things, for a practical matter, it's very influential on what shows up in the next negotiations with Dominion. And I was going to say, again, it's not just VEPCA that can have this direct contract opportunity with utilities. At local government customers of APCO do it. I know of at least one local government customer group for electric co-op, that's NOVAC, Northern Virginia Electric Co-op. Meade, I know the state has its own contract with Dominion. And the federal government, I think, sometimes chooses to intervene in jurisdictional rate cases. So you can, if you want, agree by contract to just be subject to jurisdictional rates, in which case some entities like the federal government, like the Navy, will come in and participate in a commission rate case because it's decided that it's going to follow jurisdictional rates by choice. That's the way it's choosing to do it. Now, one of the advantages to VEPCA rates, we of course hope that we're able to negotiate a rate that's a little lower than Dominion's, right? Than the jurisdictional rate, because otherwise, why would you bother with negotiating separately if you don't think you can get a better deal by negotiating directly? One part of that is that we can be evaluated separately. So, for instance, the transmission rate flows through Rider T. And Rider T for a long time was based on 1 CP. So it looked at what a customer's load was on the Dominion system at the time of the absolute system peak. And that was how transmission costs got allocated. And it generally worked out, sometimes, not always, but it generally worked out that the VEPCA load, the local government load, peaked at a different time than the rest of the customers. So, for instance, if a peak occurred in the summer, we've got a lot of school load, and that load is down in the summer. So we could benefit by the fact that our share of that peak was lower just based on the characteristics of our load. So that's one advantage you can get from, say, negotiating directly with Dominion. Another distinction is that VEPCA customers by contract have Dominion do a rate comparison every 15 months. And as a result of that rate comparison, Dominion says, well, you're on, say, Schedule 100, but if you switch to Schedule 130, you would save this amount of money annually. That's an option that's not available for jurisdictional customers because for jurisdictional customers, you're told which schedule you're on. So you're either on GS1, GS2, GS3, or GS4, depending upon the characteristics of your load, mostly based on size. For VEPCA members, there's a little more flexibility to switch back and forth between one rate schedule or the other, and depending on the characteristics of your load, you may save more on one or the other. And Dominion, by contract, is required to do that analysis every 15 months and tell us if members could save by switching. Also another advantage of negotiating directly is that, local governments are different than other customers. So, for instance, we had a working group on LED streetlights, and we were able to sit down with Dominion and say, well, this particular service is very important to us. We want you to offer us more options. So it allows us to do that kind of negotiation informally without going through a formal rate case at the commission. And how am I doing on time?
Must be okay.
Okay.
Yeah, you're fine.
Okay. So the other thing that I get questions about is municipal and state aggregation. A lot of other states, or several other states, have community choice aggregation, which means that a local government can shop not only for the load of its buildings, but also for the load of its entire all the residents in its county, for instance. So some local governments can take to market not only their load, but the load of their the customers within the county, for instance. And we do have provisions under Virginia law for municipal and state aggregation. That's under 56-589. Now, when we went back to re-regulation in 2007, another anomaly of Virginia law is that we're kind of in a hybrid situation. So most states are either allow competitive purchases or they don't allow competitive purchases. Virginia allows competitive purchases in three limited situations. One is if you're a big load. So if you've got a 5 megawatt account or larger, you can shop competitively if you feel like it. You don't have to get your supply service from your incumbent utility. Another option is aggregation. So if you've got smaller accounts, but you can aggregate up to 5 megawatts, then theoretically you can shop if you get permission from the State Corporation Commission. We found out the hard way that the commission said yes to one aggregation petitioner and has said no to everybody else. That was appealed to the Supreme Court, and the Supreme Court said it's within the commission's discretion to say no to aggregated load. So that second option isn't as viable as folks had hoped it would be. And then the third option was if you want to purchase 100% supply, renewable supply from the market. That option existed so long as a utility did not offer 100% renewable supply in one of its tariffs. So APCO was able to eliminate that option for its customers about a year ago with rider WWS. Dominion was able to eliminate that option for its customers with its rider TRG. That got approved in July. So as it stands right now, that third option isn't viable for, practically speaking, for Virginia customers. But folks have said, well, look, there's Section 56589, municipal and state aggregation. So why, which says that local governments can aggregate their accounts. So why can't they aggregate and shop not under the 56577 provisions, which I've been talking about, those three carve outs? Why can't they shop under 56589? That's a whole separate statute the General Assembly set aside for municipal and state aggregation. The difficulty there is that that 56589 starts out in subsection A with this phrase, subject to the provisions of subdivision A3 of 56577. So it's not been tested, but it's the conventional wisdom, and I don't know if Meade has an opinion on this, but the analysis I've seen suggests that that means that if you want to aggregate, you're back in the 577 realm where you need to go and ask the commission permission to aggregate. And when business customers like Walmart and Costco and Target have gone to the commission and said, give us permission, the commission said no. So it's
Just a little,
so that's probably
another day above ground.
more of a theoretical option than a practical option for local governments. And right now, via the VEPCA contract, what we've been doing historically, I don't know that we'll continue it always, but historically, it has been an all requirements contract, meaning that we have by contract said, unless you've got a situation that involves self-generation, we're going to purchase all of our supply from Dominion. Now, we have also in that contract said, oh, by the way, Dominion, if you offer renewable power options to jurisdictional customers, we would like that same benefit to be applied to VEPCA members. So purchase power agreements for solar that's on site, that's permitted for jurisdictional customers, and by contract, we've incorporated that by reference. The same thing with net metering options. So, it's null requirement contracts with that ability to take advantage of when a jurisdictional renewable power option is offered. VEPCA members can also take advantage of it as well. Another thing that's come up recently is electric vehicle rates. We do not have an EV rate in our current VEPCA contract, but we have a provision that says we can go and request one from Dominion. So Dominion has made some recent EV schedules or pilots available for jurisdictional customers, and I just got confirmation the other day that those are available to local governments. But in addition, if we wanted to have a standalone EV tariff in our in the VEPCA contract, we could. So Joe, that's what I've got.
Thank you, Cliona. Just so everybody knows, as Cliona was mentioning certain things, I put them in the chat. And also what I will do is we will have a dedicated web page with some of these links So that'll be great. I could just maybe just add a couple of things because for about 7 years, I was the secretary treasurer for VEPCA, and I learned a lot. And one of the things that just really amazes me is how much I think over time in millions of dollars in the aggregate, the VEPCA contract has saved Virginia governments. And I think something similar can be said of the VML VACO APCO steering committee contract. So I just say that, and just a little bit on the PPA, the purchase power agreement. We do have that in our draft legislative program, just more flexibility for localities to do that. There was an interesting piece of legislation this past year that had a carve out to allow one of our localities, Fairfax County, to do a PPA larger than I think what the max that you could do as far as size was 2 megawatts. And they're able to go up to 5 megawatts on a solar installation on their old landfill. So that's kind of an interesting thing. And Mr. Chairman. All right, so our next speaker is Meade Browder, Senior Assistant Attorney General, the Chief of the Insurance and Utilities Regulatory Section, and this is with the Office of the Attorney General. The primary function of this regulatory section is to serve the AG's Consumer Counsel function, pursuant to the Code of Virginia in matters related to the regulation of insurance and utilities, particularly as such regulation affects rates or service for monopoly service. Now, the section doesn't have actual agency clients, but instead represents the collective interest of citizens and businesses of the Commonwealth in their capacity as ratepayers and consumers in areas of public utilities and insurance. And this includes local governments as well. So I'll go ahead and turn it over to Meade.
Yes, thank you, Joe. First, make sure sound check, my mic's on and everything. Okay, good. Thank you for inviting me to appear before the Energy Subcommittee here at the Virginia Association of Counties. It's a pleasure to be on a panel with Cliona. Cliona made the comment earlier that I wholeheartedly agree with, that our State Corporation Commission has a very strong staff, and that's true. But we also have a really good utility bar in Richmond, and it makes practicing in this area really enjoyable because the people we're dealing with, like Cliona and others like her, are all very knowledgeable and very collegial. So it's one of the real nice things about practicing in this area. I probably should first begin, anytime before I speak before a group like this, and being from the Attorney General's office, it's just to give sort of a blanket disclaimer, a CYA, if you will. Any formal legal policy positions of the Attorney General's office are those that are appear in on the record and filed cases, briefs, testimony, what have you, or statements in court, or through the kind of official media channels of the Attorney General's office. So I think I don't think anything I might say or response to questions would be contrary with views of the office. I just want to give that general disclaimer. I thought it would first make it just be a little bit helpful, in case not everyone knows this, of just sort of explain the specific role that the Attorney General's office has in energy regulation areas. I sometimes will, when there's articles in the paper or things about utility matters or before the General Assembly, and our office has weighed in on something, I sometimes like reading the people's comments, particularly online papers and things. And sometimes we see a comment, why is the Attorney General involved in energy regulation? Shouldn't he just be focused on criminal law and things like that? So I think that's helpful to make sure everyone knows that. And so in 1970, the General Assembly created within the Office of the Attorney General the Division of Consumer Counsel. And the statutory duty of the Division of Consumer Counsel within the AG's office is to appear before governmental commissions, agencies, and departments, and expressly includes the State Corporation Commission, to represent and be heard on behalf of consumer interests. So really, it's before the State Corporation Commission, before the General Assembly, and also from time to time before federal agencies, specifically Federal Energy Regulatory Commission, as it applies to utility matters. Our mandate is a little bit different from that of the commission staff, which again, Cliona referred to earlier. The commission staff's role is to develop the record in cases at the SCC and also appear before the General Assembly. But really, their job is to represent the broader public interest, whereas we have a more narrow focus, and that's to represent the ratepayer consumer interest. And they're similar, but the public interest is also to consider the interest of utility companies and other broader interests, not just the narrow ratepayer interest. So we're much like any other attorney-client relationship. Our client is the consumers of Virginia. Obviously, there are millions of consumers in Virginia, all different types of utility consumers, from residential homeowners or renters, small commercial customers, mom and pop businesses, large industrial customers, commercial customers, Walmarts, Kroger's, and you've got consumers that may be in, use Dominion as an example. Some there may be in Fairfax County, in the wealthiest county in the state. You may have others that are, say, in Brunswick County, where my father grew up, in a little bit different economic situation. So how we try to do that is really just look at two things. One, we focus primarily on residential and small commercial customers. The larger customers would typically have their own representation, whether it's before the General Assembly or in SCC cases. A large industrial customer is going to have their interests represented. Same with the Walmarts and the Costco's and Kroger's and people like that. So we focus on those customers who would not be practical or realistic to expect that they can go out and hire an attorney to represent their interest before the General Assembly, before the SCC. And then even within that group, there's obviously different, widely different views, just like on everything, but also on in utility areas. So we try to focus on basically the collective body of all ratepayers. Certainly, some may want to be. Affordability could be an issue for some and not for others, but we really look at it as what's cost of service and just and reasonable rates, and advocate again on the collective body of all ratepayers. We also, within the Attorney General's office, there are certainly other sections of the office that are engaged in matters that affect utilities and environmental issues. One example would be the environmental section of the office. They represent the Department of Environmental Quality, might represent the Department of Mines, Minerals, and Energy. But basically, they do their thing, we do our thing. Again, focused on representing the Virginia citizens as consumers. I've been in the office since 2002, so that goes back to Attorney General Kilgore. And I guess we don't leave anybody out. I guess that was then McDonnell, and then Cuccinelli, and now A.G. Herring. So 4 different administrations. I think it might surprise some people to hear that in our work before the General Assembly or before the SCC, it's not really top down. It's the Attorney General, and from those that I just mentioned, they've had kind of opposite ends of the political spectrum, but they don't typically come to us and say, okay, Meade, I need you to get this outcome or push for this particular result, based on my particular political views. It's really more the ground up. We hire expert witnesses, experts over the years that have developed a lot of familiarity with Virginia and with Virginia utilities, and we really just look at the facts and the law as the law may change over the years, and advocate for the best interest of ratepayers based on that. And obviously, the attorney generals are always actively engaged and informed of the positions that we're taking. And obviously, I never take any position before the General Assembly or before the FTC that the attorney is not briefed on, informed about, and okay with. But it's not this sort of top down. I guess really a way of saying it, we really don't take political positions, again, in representing the ratepayer interest. So that's been something that I think has been very the lot of attorneys in the office really appreciate the knowing that they can just go out there and represent based on the facts and the law on behalf of the ratepayer interest, and really it's not a lot of political pressure to advocate one position versus another. Returning more specifically to kind of current issues in energy regulation in Virginia, Cliona touched on some of the history back to 2007, re-regulation. I guess it's been in the last 2 decades, 5 major legislative actions in Virginia. There was first in 1999, the deregulation or restructuring, probably the better term, Restructuring Act, that was to set Virginia on the path of deregulation, meaning you could choose your generation supplier, retail choice. Wasn't going to deregulate the distribution part, but the generation part. And that was the path that had been taken by California and a lot of states to the Northeast, DC, Maryland, Pennsylvania, all that. There was a lengthy transition for that. And as Cliona touched on, when we got to 2007, so in other words, it wasn't a flash cut to deregulation. You could stay with your current provider, and if not everybody, probably 99% of customers did. Won't get into all the specifics and details, but the way the law was drafted, it really made it economically infeasible for someone to switch because of a wires charge and some other jargon. But anyway, got to 2007, as Cliona touched on, at that time, wholesale power prices were very high and really driven by natural gas. And that in turn made retail prices high. So for companies that were deregulated, you're no longer in a cost of service environment. So you may have historical assets that are would not produce high costs, but in a deregulated environment, sort of whatever the current marginal costs are, that's the rate. So long story short there, the commission the General Assembly looked around and said, yeah, we don't think it's be best to kind of jump off this cliff of deregulation. We're going to re-regulate. We did not return to pre-1999 cost of service regulation. We refer to that as Chapter 10. That's the part of the code, Title 56 of the code. Chapter 10 was basically cost of service, commission to set just and reasonable rates based on cost plus a reasonable rate of return. And that went back to the 1940s or whenever the SEC first started regulating the utilities. But instead we came up with this sort of I'm not sure how it was unique to Virginia. It involved a concept called biennial reviews. You look back 2 years and see how the company, how their earnings were. And if they were within a band of authorized return, then you left rates where they were. If they had under-earned, and the utility could petition for a rate increase, looking forward at future costs. If they had over-earned, and that's where it really got interesting, because Dominion was in a sort of historical over-earnings position. If you over-earn, the utility could keep a percentage of the over-earnings. It had to refund a percentage to ratepayers, but then it could keep the rates where they were. The rates that had produced those over-earnings, commission could not lower them in that first case. There had to be 2 successive biennial reviews, or other 4 years of over earnings before the commission could reduce rates. And as I mentioned, APCO is a little bit different position than Dominion. APCO had a lot of environmental compliance costs that was putting upward pressure on their rates. They had a lot of coal. Dominion was their generation was more diversified and was not facing the same type of costs. So for a variety of reasons, Dominion's rates were producing very healthy returns for the company. But the commission was limited in what they could do to reset those rates. And then there was really just a kind of a series of bills over the years up until 2015, sponsored by, or I guess you could say sponsored by Dominion, obviously had a legislative patron, that were really designed to sort of micromanage the commission rate setting process. And if there were a particular cost that was coming along that maybe the company would like to accelerate and kind of dump into that biennial review to keep the earnings down, and there were legislative provisions to do just that. One example was the North Anna 3 nuclear development costs. That was the new reactor that was going to be built, or at least in the planning stages, it never got built. But there was legislation, as an example, to put $500 million of cost for that kind of into a specific time period that reduced earnings. So anyway, we got to 2015, and that was the sort of the notorious rate freeze legislation. It was pitched as a way to protect ratepayers from what was believed to be costs that were coming from the Obama administration's Clean Power Plan. That Clean Power Plan never was never put into place due to the change in the federal administration, so it never came to be. But nevertheless, Dominion was successful in persuading the General Assembly that it'd be a good idea to freeze rates to protect ratepayers from something that might happen, so that meant no biennial reviews for a period of years. Again, with respect to Dominion, they pretty much locked in rates that were producing high returns. I think over time, people started to realize that, hey, maybe this wasn't such a good idea. It was pitched to protect ratepayers from a federal environmental regulation that never came to be. So why are we doing this? So in 2018, there was legislation to restore the review process. Actually, this may be interesting to some of you. The rate freeze legislation was actually appealed to the Virginia Supreme Court. All decisions from the SCC can be taken to the Supreme Court, and it was argued that that the General Assembly had acted unconstitutionally in kind of removing from the SCC the authority to set rates. That the General Assembly was basically stepping into the SCC shoes to set utility rates, and that violated a provision of the Virginia Constitution. It was ultimately decided by a majority of the Supreme Court that the General Assembly did have the authority to do what it did. There was, I believe, two dissenting opinions. So that was a pretty significant, or very significant decision of the Supreme Court in sort of testing the bounds of how far could the General Assembly go into the SCC's rate setting authority, and the decision was, well, they can go pretty darn far. So in 2018, we got what was termed the Grid Transformation and Security Act. It resumed the reviews of Appalachian and Dominion, put them on a 3-year schedule instead of 2 years. We just concluded, Appalachian went first with a 2020 case, so we just concluded the hearing in September on that case. Order will be out in November from the commission. Dominion's case will resume in 2021. We'll be looking at the past 4 years. There's a lot of detail and things that went into this law that I won't get into here, but something called customer credit reinvestment offsets, where if there are over earnings, if the company has made new investments in certain, whether it's grid or distribution system enhancements, renewable resources, the company can take past over earnings, and rather than refunding those to ratepayers, can basically kind of prepay for those new investments. Depends upon your perspective whether or not that's a good thing. I guess it's nice to say that new investments can be made without having having to pay for those over time. But another way of looking at it is like, well, it's almost like forcing you to prepay your mortgage. You know, you've got you may have $100,000 sitting in the bank, and you have $100,000 left in your mortgage. It's sort of like saying, okay, well, you got to take that $100,000 and pay off your mortgage all at once. Well, a lot of people might say, well, you know, I really don't want to do it that way. But anyway, I'll leave it at that on the Grid Transformation Security Act. That then brings us up to this year, 2020, where we had the Virginia Clean Economy Act. And that was a very significant legislation. It did not really, it did not change the rate setting, the triennial review process that was established in the 2018 legislation, but it put in place a lot of goals and to some degree mandates for new renewable generation and renewable portfolio standards for the utilities to reach certain percentages of generation coming from renewable energy. With respect to that, our office, we did not, we neither really supported nor opposed it. What we do, and with all legislation really for the General Assembly, is to just present factual information about the ramifications of certain provisions of bills. And much of what was in the Clean Economy Act were renewable initiatives that the Attorney General was very much supported. But as it was originally drafted, there was one provision in particular that caused us a lot of concern, and that was it effectively removed the Commission's ability to determine the reasonableness and prudence of particular investments. And that's just been historically one of the core responsibilities of the State Corporation Commission is this project that's going to cost $100 million, $300 million, $1 billion, $8 billion, is it reasonable and prudent? Meaning, is it going to be economic to ratepayers compared to other alternatives? So we were successful in, I'd say for the most part, in having some provisions stricken from the bill that was going to essentially tie the Commission's hands in determining reasonableness and prudence of new investments. Now, I would say with respect to the largest investment, the offshore wind project, at least 2,600 megawatts of offshore wind. The way the bill's written, it's pretty much. We'll see what happens when the filing comes in, but there's not a lot of discretion for the Commission on that. I'll probably just leave it at that. I don't know. I don't want to kind of prejudge the case or positions we might take when we get to that. Certainly, that will be a significant economic development project if it goes forward. But the economics of to the ratepayer, that may be another story. Also, so focusing on the I'll touch a little bit further on the Clean Economy Act specifically before I kind of close my remarks. And one thing that I found sort of interesting in the Clean Economy Act, that there's sort of an internal tug of war between some of the initiatives of the legislation. And I think to set this up, it's helpful to understand that load growth, meaning that customer demand for electricity, load growth in the Commonwealth has been relatively flat for quite some time, and really since the Great Recession of 2008, 9, 10, load growth has been largely decoupled from GDP, economic growth, and I think it can be due for a lot of reasons. Greater efficiency. Everybody, a lot of people now have more efficient housing stock and HVAC systems, and all those things have just led to, instead with businesses, have led to really flat growth. So you generally build new generation to meet increasing load growth or to replace generation that's being retired. But with load growth being flat, there's questions about, well, is there really a lot of need for new generation? But the Clean Economy Act does encourage significant amounts of construction of new generation. It's likely that somewhere probably around $40 billion in capital expenditures over the next 15 years. And of course, customers ultimately have to pay for that. The new law declares to be in the public interest and indeed requires Dominion to petition the SCC for approval of 16,100 megawatts of solar or offshore wind, and within that, up to 5,200 megawatts must be offshore wind. And as I mentioned earlier, essentially mandates 2,600 megawatts of offshore wind. There's also 2,700 megawatts of energy storage capacity that the company must petition approval for. With respect to Appalachian Power, that utility is required to petition for approval of 600 megawatts of solar or onshore wind and 400 megawatts of energy storage. One thing I should say about that is that the legislation calls for a 35%, 65% split between PPAs or purchase power agreements and utility self-build generation. And it's certainly been our office's experience that the PPAs offer renewable energy at a much lower cost to customers compared to the utility self-build projects. That may change in the future, but that's only been our experience to date. And we have been very supportive of PPAs when utility comes to the commission with approval for cost recovery of a purchase power agreement. And there's a variety of factors of why they're more economical for the ratepayer. And the main thing is just that all risks are on the developer. So the utility purchases the output from the facility and then passes that on to the ratepayer. But if that output is down for whatever reason, if the solar panels are needing repair, or if they don't reach the production targets that they were expected, well, there's just less energy output to the utility that they in turn pass on to the ratepayer. If the utility builds it themselves, then all costs of the project plus return are passed through to the ratepayer. So again, we think that the PPAs are really the most economical way to go for renewable energy from the ratepayer standpoint. But I mentioned sort of the tension and tug of war in the legislation. On the one hand, we have these mandates for the company to seek new construction generation, but we also have policies in the law that encourages reduction in load requirements. And one example of that is new standards for energy efficiency programs. For APCO, by 2025, the utility is to implement energy efficiency programs to reduce load by at least 2% of annual average energy jurisdictional sales. And for Dominion, by 2025, they are to implement energy efficiency programs to reduce load by at least 5% of annual energy sales. So again, all good things, but again, there's a little bit of tension there between measures that will reduce load on the same time measures mandating that you add more load. So sort of a main takeaway there is that we certainly would like to avoid having our utilities have excess generation because ultimately the customers are going to have to pay for it. Let's see. The other thing I'll just touch on, and Cliona touched on this a little bit as well. We have this sort of hybrid system in Virginia right now. We're not a full, monopoly, cost of service regulated jurisdiction, like say North Carolina or South Carolina, but nor are we a full retail choice jurisdiction. There are specific carve-outs for customers who may want to leave the utility. So on that, again, our issue, I know Cliona has been very active in this issue for a variety of customer interests, but from the standpoint of the the rate, the collective body of ratepayers that I mentioned that we try to look out for. The real focus there is on legacy costs. And, when utilities, when they built major, generation resources, they are long-lived assets. They have to be paid for by customers. So if a large industrial customer or a bunch of customers who've aggregated together, if they leave the system, again, not the distribution system, but the generation system of Appalachian or Dominion, that means they're no longer paying for these legacy costs. So that's an issue that will be before the commission. There's some petitions that have been filed just in the last month to try to sort out how that would work. Issues over non-bypassable charges, meaning if a customer does choose to leave, take its load to another competitive supplier, what generation-related costs must they pay to the utility that are considered sort of stranded or legacy-type costs? So that's something that we will be looking at to make sure that, again, the mom and pop, smaller commercial or residential customers who are staying with the system are not being overly burdened, but at the same time being responsive to the legislative option that those customers may have to go elsewhere. So, like Cliona, I think we could talk for hours about all the things that have happened in the past or may have, or even are pending right now in this area. There's a lot going on. We've moved from the days of utility regulation being kind of stodgy and never being in the newspaper to now being very newsworthy issues. So it's an interesting time to be in this field. With that, I'll wrap up the prepared remarks, but certainly happy to try to answer any questions. Mr. Peterson had the question. I think he got a good answer on that, but maybe just to clarify one thing he asked about the arrangement with Anthem. And we've seen that now. I think one of the first ones we saw was Amazon. Some years ago, Amazon made a big announcement about taking solar power from the Eastern Shore with some arrangement with, and obviously Amazon's facilities. They have a lot of server farms, but they're not in the Eastern Shore, of course. These things are really complex and maybe a little bit different arrangements in each case, but for the most part, they're probably buying the renewable, the RECs, the renewable energy certificates. So they're not leaving the Dominion system, but they're probably buying the renewable attributes of that generation facility. There's other arrangements that some utilities have made where they, all this energy goes into the grid. The PJM is the name of the regional grid manager, and they run a wholesale market for energy. So they can work out things where they're kind of buying it, sort of equivalent of the wholesale price, but it goes a lot deeper than what the headline makes it sound, that a company has contracted directly with some generation, renewable generation. It doesn't work quite that way. Oh, that muddies the waters further or helps, but a lot of times I read these things myself and say, well, how is this, how is this possible? This is not right. So.
Mr. Chairman, I got a question in the chat, and this might be for both Meade and Cliona. It says, this is from Ian Malik. Meade, you mentioned portfolio standards. Are those just for producers, or are they also for Virginia businesses that they have to purchase a percentage of their electricity from renewables? This is needed for those of us with unpurchased REC credits to have a market. Yeah, it's what I was referring to in the Clean Economy Act were requirements that for Dominion and Appalachian Power that increasing percentages of their generation be renewable resources. So it's from the standpoint of the utility generation portfolio. It's not from not from the standpoint of the customer. And obviously, a customer is just taking
it's not shopped, it's not gone with, it's not aggregated or shopped from an alternative supplier. Just taking this kind of what I call the standard offer service from their monopoly utility. Obviously, as those utilities increase their percentage of renewable generation, of course, the customer will. That's what they'll be getting, at least as an accounting measure. Like Cliona mentioned earlier, electrons just go where they go on the grid. So.
And I think that issue is going to be litigated in the non-bypassable rate case that Meade just mentioned. If you're buying 100% renewable already, how much of the RPS cost should be borne by those shopping customers, and as Meade said, how much should be borne by those that aren't shopping. So I think that's going to be robustly discussed in the non-bypassable charge proceeding.
All right, Mr. Chairman, I don't know if we have any other questions.
Anybody else have any other questions for either of the speakers or for Joe? If you do, just unmute your mics.
Oh, there is another question. Ann followed up with that. The 5% demand reduction, I guess that's the energy efficiency that is for Dominion, but then APCO's was 2%. Are those to come from grid modernization?
I'm sorry, are they?
So some of the energy efficiency targets that are in the VCEA, can that come from grid modernization?
Yeah, I expect a lot of this is sort of all intertwined. The grid part of the grid modernization, and that term can include a whole host of things, but there are certainly elements of that will would help the utility. How do I say this? Better handle taking in or absorbing distributed. A lot of renewable energy is what we call distributed generation, more rather than kind of a big power plants. Maybe far from where the load is and have to come across transmission lines. While renewable is more distributed and around, closer to the distribution network. So some of the grid transformation efforts are to better accommodate that type of generation. Also to better facilitate things like time of use rates, time of use meters that would help reduce load. So it's all sort of wound up in the same ball of yarn, so to speak. But a lot of it's focused on energy efficiency programs, demand side management programs, energy efficiency programs, things of that nature.